For Women's History Month, we'll focus on the Equal Pay Act, some historical developments, including changes in 2023, and end where you can learn more about your rights or obligations. I'm attorney Steve Matcha. I've helped many employees resolve workplace issues, and I encourage you to reach out to me with your legal concerns. As the name suggests, the Equal Pay Act prohibits employers from paying employees less than others of a different sex, race, or ethnicity for substantially similar work. And while I've been referring to the Equal Pay Act, there's more than one. California first enacted its Equal Pay Act in 1949, and the federal government followed suit in 1963. The federal act was then amended in 2009 as the result of a lawsuit brought by Lilly Ledbetter. Ms. Ledbetter had been receiving discriminatory pay for 19 years and won her discrimination case before a jury, but lost after several appeals going all the way up to the U.S. Supreme Court. The issue on appeal was the time limit for Ms. Ledbetter to file her lawsuit. If the time limit started when she received the unfair pay, her lawsuit would be timely. But if the time limit started when the employer made the discriminatory decision to pay her unfairly, her lawsuit would be thrown out for being filed too late. While the court ultimately ruled against Ms. Ledbetter, Justice Ruth Bader Ginsburg described the majority opinion as a cramped interpretation of Title VII that was incompatible with the statute's broad remedial purpose. Since courts basically interpret laws the legislature creates, Justice Ginsburg further suggested the legislature may act to correct this court's parsimonious reading of Title VII, and the legislature did just that. Hence, the Lilly Ledbetter Fair Pay Act of 2009. As for California's Equal Pay Act, it was amended in 2015, 16, and 17 to include race and ethnicity, both public and private employers, prohibit employers from seeking or considering salary history in pay decisions, require employers to provide pay scales, that's the salary or hourly pay ranges, to job applicants upon reasonable request, and allow employers to pay employees differently for non-discriminatory reasons, like education or seniority. Starting in 2023, the Act changed again to include more pay transparency. The basic idea was to shed light on pay practices to help identify and reduce wage discrimination. For businesses with 15 or more employees, the law added three major requirements. First, those employers now need to include pay scales in their job postings, whereas before they could withhold that information until job applicants requested it. Second, current employees can now ask for the pay scale for everyone in their same job, and employers then have to provide it. Third, employers now have to keep a record of job titles and how much employees in those titles were paid throughout their employment. And employers need to keep those records for 3 years after the employment ends. The Labor Commissioner can then check those records for indicia of possible wage discrimination. You can visit the Equal Employment Opportunity Commission's and the Department of Labor's websites to learn more about the Federal Equal Pay Act. And as for the California Equal Pay Act, check out the Labor Commissioner's frequently asked questions, which have been updated to include the 2023 changes. You can also go to the resources page on the website of the California Commission on the Status of Women and Girls, and I'll add links to these sites in the description. Feel free to reach out to me again with any legal questions, and remember to like, share, and subscribe for more videos like this, and your comments are welcome. Thanks for watching.